A very good afternoon to everybody, and welcome to another episode of BHBA Family Law Presents Direct Examination with Dan and Lauren. I'm Dan Bemmel, financial advisor and certified divorce financial analyst. During each episode of our show, we explore our guest's personal and professional history and dig into meaningful legal topics. I am so happy to welcome back Lauren Youngman from Youngman Reichstein. We all missed you. We're so glad you're back. And excited to continue on. We also, of course, owe a big debt of gratitude and have to give a huge thank you to Samantha Klein, the head of the West Coast Family Law Practice at Withers, for filling in as our guest host while Lauren was out. Absolutely amazing. So thank you, Sam.
I'm so happy to be back, and I'm very, very grateful to Sam Klein for stepping in and doing such an amazing job with you in my absence.
All right, well, everybody, please continue to join us for our upcoming episodes, almost always at 12:30 p.m. live on Zoom. We have a great 2024 schedule shaping up here, starting with supervising judge Shelley Kaufman on January 10th because of the holiday, followed by Michael Trope, Kimia Klein, Adam Lipsick, Evan Itzkowitz, and many more throughout the year. Lauren?
Thank you, Dan. So just housekeeping, everyone will receive their MCLE certificate shortly after the program. Please take a moment to complete the survey that's included with your certificate. The family law section is sponsored by White, Zuckerman, Warsofsky, Luna, and Hunt. White, Zuckerman, Warsofsky, Luna, and Hunt provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. That's it for our sponsor.
Okay, well, everybody, don't adjust your screens. You're not seeing double. We have both Clemens brothers with us for today's program, and it's cool that it's an even more special program because today's Keith's birthday. So happy 35th birthday, Keith. I think that's it.
That's about right. That's about right.
Okay, well, Keith is, of course, retired Commissioner Keith Clemens, longtime family law judicial officer, currently a private judge. Bruce Clemens is one of the longest tenured family law attorneys in Los Angeles, formerly of Jaffe and Clemens. Together, they have a wealth of knowledge and experience, which they now both put to work as neutrals at the Alternative Resolution Center. So let's start there. Your current practices as neutrals, how attorneys should be using mediation services, ADR services, and then we'll go back in the time machine and hear a little bit more about how you both ended up in the same place, which is kind of crazy to think about, the divergent paths ending at ARC together. So Bruce, I want to start with you. As a practitioner first, how has your approach to settling a case changed as a mediator compared to when you were trying to settle a case as a litigator?
There's actually a lot more similarities than differences. We're still doing the same thing. We're still trying to find laws and facts, how they fit together, feelings of the parties, a special agenda, asymmetrical valuation. The same thing is worth much more to one than the other. And when you're an advocate in litigation, you're still settling 95% of your cases. When you're a mediator, hopefully you're settling at least 95%. And the only difference is that you don't get wrapped into, I have a client to satisfy implicitly at the expense of the other side. That's the fundamental difference. You could write books on the differences, but there's really more similarities.
Keith, what about you? Do you have a particular philosophy or general framework for settling cases, or what are your favorite tools that you use?
Well, basically, family law, one size does not fit all, and we all have a toolbox. Lawyers do, judges do. And I'm constantly looking to see, is there a particular tool I need to pull out of my toolbox at a particular moment? And there are numbers of ways to get cases settled, and I try and utilize it. ask a lot of questions. I certainly read everything that I see. I depend upon the lawyers to tell me as much as possible about the details of the case and what the issues and disputes are, and we go from there.
Is there a big difference between going between private judging and mediation, either in terms of your approach or the skill set that you call on?
I think that it's different in the sense that when you're acting as a private judge, which I do, I have two jobs. One, of course, is to try and decide the case in a manner that reflects what the facts and the evidence is. And when it comes at the same time, one of my goals is to make sure that the parties and their lawyers understand that they've had a fair hearing, that they've been heard, they've been understood, they've certainly been treated with respect. But at the end of the day, as a judge, you make a decision. As a mediator, of course, your goal is you have no actual coercive power, as you do when you're a judge. And your job is to see if you can find a resolution that everybody can accept. In that sense, it's very different. On the other hand, when you're a sitting judge, you also engage in a certain amount of settlement talk, and so again, it's the same job, different aspects of what you're trying to do to get a case resolved.
This one is sort of for both of you, whoever wants to jump in. What do you try to communicate to the parties in a mediation to help encourage settlement or resolution?
Well, one is, of course, to remind them that their case is going to be settled. It's either going to be settled by agreement, which invariably is going to be better than if you go to court, because the parties know the details of their lives better than the judge ever will, even after you read everything and listen to everybody. Or it's going to be decided by a judicial officer. And so their case will be settled, and there's an incentive to try and encourage the parties to discover that they'll be better off if in fact they can get to an acceptable agreement.
Bruce, do you have the same approach?
Yeah, but yes, and just listening to Keith, not the ultimate, but an important component is to try to get trust and respect, that you really are genuinely trying to help them. You genuinely are not biased, and you generally have some special skills, special experience, or something else that's valuable enough that maybe what they couldn't settle before on their own, they can now settle. And it's not just, oh, how wonderful I am, or here's my resume. It's really hearing what they're communicating, adjusting to it, giving it back to them, and having them think, okay, that's somebody I may not agree with, but I want to hear because they've got the potential to be really special. And that's part of the process.
I love that framing of talking about what you're trying to accomplish and how you're building trust with the parties. What should the attorneys be doing in that setting to really be moving the ball forward? How can they help you tell that story?
Well,
not all at once, guys. Go ahead,
Bruce.
You know that because, look, as an attorney, I always was in an. If I was not the mediator, but I was in a mediation for a party, it's complicated. I want my client to be very proactive and involved. They need to feel that their attorney is an advocate for them, but they'll actually be worse off if their attorney takes over, advocates hard, and just pounds. And I think the tail end of that was, I remember before I became only a mediator, one of the later events I had is there was a very well-respected judge who I had appeared in front of and was then a private judge doing a mediation. And they told the client, me, how they looked at the case and what would likely happen in court. And I had to say honestly to the judge, I appreciate your view. I got that's what would likely happen in your courtroom. I don't agree with the probability that it's that likely to happen throughout, and we're there. Then I talked privately to my client and I said the exact truth. I disagree with the judge. I think it's possible. I don't think it's likely, as the judge said, but you just learned something extremely valuable. That's a great judge. And at least we know in front of that judge, it wouldn't have gone the way you wanted, and it wouldn't have gone the way I thought. And you have to consider that, even though I don't agree with what they just said. That's what a lawyer does that helps. And then privately, sometimes the lawyer speaks to the mediator and says, here's the problem I'm having with my own client. Here's the benefit and the special part of my own client. And if you can use this in your process, I want you to know it. But this you can't tell the other side, but I trust you and I want to be candid with you.
Well, what if the other attorney is the problem and the other attorney is not really invested in settlement or to move the case forward when you're in mediation? What can the other side do, and what have you done as a mediator in those situations? Maybe we'll hear from you, Keith.
Well, for one, when you run into that problem, one of the things that you as a lawyer are going to want to do, and probably the mediator will too, is talk privately with the mediator. And the mediator's job is to talk privately with each side, including the lawyer who is doesn't seem to be engaged in actually trying to resolve the matter. And it's a lot of different ways to deal with it. Find out what's going on and find out, and sometimes you just have to be blunt, say, are you serious? Look, at the end of the day, we don't have coercive power. We have persuasive power, and that's it.
Right.
And if somebody, in fact, really, truly does not want to get engaged and does not want to, is there because they're forced to go through this process, it becomes very, very difficult. But even then, occasionally, you can get somebody to start thinking about the problem, and you can formulate a problem that gets them to thinking about a possible solution to get what they want. And now they're starting to be engaged.
So
Sometimes
same
works,
with the
it
parties, right? Same idea, whether it's the attorney or the party.
Absolutely.
So we're talking about coercive power, persuasive power. From an attorney standpoint, it seems like oftentimes one of the biggest threats is the threat, well, then we'll just go to trial. Does that ever work? Is that ever beneficial? Does that ever produce something positive, or does that always kind of turn the temperature up with bad results, Bruce?
Well, I think we all, as lawyers, as judicial officers, as mediators, have the same thing. When somebody appears to be shutting things down, is it bluster? Is it strategy? Is it genuine? Is it a personality defect, et cetera, et cetera? And about all you can do in the short time when that comes out is you simply restate what they're saying, except in a better way. Say, I understand. If you're not satisfied with this process, you'll choose trial. Everybody has that right. And the reason I'm trying to help is this is what I think that choice would involve. And these are the opportunities that would be lost. But you're absolutely right. If this doesn't work out to everybody's satisfaction, there's no agreement. If there's no agreement, there's a trial. Thanks for reminding us. Now let's see if we can get the better solution.
I like that, refocusing back towards settlement.
And if that doesn't work, the one time there were two lawyers and one was very, very difficult. And the best I could do was shrink them both and say, I need to hear for a little while only from each of the parties. Because if they're not involved directly, then they won't have been heard and it won't work. I also, in most of my mediations, when I can, I have a pre-meeting with the parties, each side, and almost always there's a more dominant, more knowledgeable, whatever it is, party. And there's lots of things to say about why that doesn't work, but I give them a little rule. Even if you know everything and the other side knows nothing, if you're talking more than half of the time, the process is likely to fail for reasons that are more than just mechanical, economic, and whatever. So, and I talk to the one who's embarrassed or uncertain about talking and say the same thing. If you aren't doing 50% of the talking, we're much less likely to succeed. And I get everybody's buy-in on that, and it changes everything.
You know, talking to each party separately like that and sort of prepping them for the process, that actually leads perfectly to my next question, which is about format. Is there a specific format that you each follow in your mediations? And is there a significant difference that you found doing them online versus in person?
As I said, in family law, one size does not fit all, and that applies to the process too. Sometimes I find it useful to bring everybody together even beyond the opening 5 minutes in which we explain the ground rules and why mediation is safe. And sometimes you go, I'll do that opening speech and immediately separate the parties and go from there. It just depends.
What about online versus in person?
Online versus
Yeah.
Actually, I like doing online mediations. I find that they work, in my experience, have worked very well, and occasionally work better than the in-person ones. Now, sometimes, it works out that having everybody there does help. But a lot of times there'll be some issue, and when you're doing it online, it's very easy to take a break and people can go get information. We can reconvene in an hour, or much later that day, or the next day, or whatever day works. And because people don't have to travel and gather and find a big block of time to reconvene, doing it online makes that absolutely possible. And of course, it's very easy to have lots of private conversations on Zoom, but of course that can be done in person too.
Well, I don't know about all of you. I'm sorry.
Do you favor one or the other, Bruce?
I do. Surprisingly, I favor Zoom. And what I was going to say is I'll give you a very unofficial survey result at where Keith and I both work at ARC. The majority are retired judicial officers, but some number are attorneys who have not been on the bench. And about half of us get together by Zoom with some regularity. And we've all lived through this change over to Zoom. And there are still some who strongly favor in person. There are still some who strongly favor Zoom. The vast majority are at least as comfortable with Zoom and optimistic as in person. And probably 2/3 of them had the same experience, doubting that Zoom would work or doubting that it would work well, and being won over. And it took 1 year, 2 years, quite a while. And so that's one group, one experience. So that's not just Keith's view and my view. The majority of them were shocked or surprised how well Zoom works in mediation. And there's a whole bunch of reasons for that.
Well, expand on that. Why do you think it does work so well in mediation specifically, or what about the mediation process itself lends it to that format?
Well, it would take a lot to talk about all of the things, but I can tell you one of them. Unlike today, in a Zoom mediation, it's not recorded, it's private, it's confidential. And I don't care how you say that, swear to that, prove that. I think parties, especially, and the attorneys somehow feel that what they say and do, they're more accountable than if they were just sitting in a room where they could say anything and pound the table and there's no recording, there's no history. The fact is, they can't. It's all covered, by confidentiality. But I think they act better. The other thing is, we can get at 3 p.m. and there is one issue that's just blocking the settlement. And it is so easy to say, how about tomorrow? Can we meet for 30 minutes at 5 o'clock? It's so easy to do on Zoom. It's so difficult to do with the travel and the parking. So that was just a couple of the differences. It was also easier to have pre-meetings with the parties and the attorneys. And finally, when you're in with one side in an in-person mediation for an hour, hour and a half, it's in the back of your mind. You've got the other side just frozen, twiddling their thumbs. If they're on Zoom, they can do other things. You can have an arrangement. You'll call them on the cell phone and get them back. There's a whole bunch of reasons that Zoom is there. There is, by the way, the opposite answer. When you're looking somebody straight in the eye, face to face, it is a different communication.
Does that change? You talked at the beginning about building trust as part of your process. Is that harder? Is that easier in person? You're talking about face to face. Keith, do you feel like there's a difference there?
I don't feel it, but I can't give you proof one way or another. I seem to have about the same rate of success in settling cases either way. And I don't feel the dynamic being very different.
Keith, we talked a little bit about the difference in having the weight of and the authority of the bench. Does that change how you look at the issues? Does that change what are the more challenging issues in an ADR setting versus in a trial setting?
Well, all I know is what I bring to the party is, the experience of, thinking like a judge. And, I don't know whether that's all that different from the way that somebody like, Bruce, who's been a litigator all along, approaches it. But I don't feel a real difference between being on the bench or being private. But, having done that, I suspect that does affect how I look at everything.
Keith, what do you like the most about the mediation process? What do you find the most satisfying?
Well, it's fun to help people get to a resolution. We all know, that in family law, we see the best people at their worst. This is a tough, miserable process for most people. And, we get to help them. This is I find the family law just fascinating because it's real people, real lives, and real stakes. And it's fun to help people get through it.
So when you're stuck at the end, Bruce, how do you get over the finish line? Those small issues, and we've all seen them, that are hanging up the case for whatever reason, whether it's a psychological control issue or maybe some final thorny financial issue. How do you get it over the finish line? That last stall, what's that final push?
It's the same thing you do start to finish. Educate, understand, be creative, help everybody see the consequences of the alternatives.
So consequences, let's talk about consequences again. We talked about trial being one of the consequences. it seems like more and more, maybe more in a litigation setting, contempt is kind of a topic du jour at the bar. Does that ever work? Does talking about contempt, maybe making a contempt argument, ever work? Maybe put your litigator hat back on for a minute. And Keith, your judicial hat, of course. Bruce, let's keep going with you. Does contempt ever work?
Almost never. And when Dan Jaffe and I were Jaffe and Clemens for over 4 decades, we concluded very early on that almost always contempt was not going to be a good next step forward. They were expensive, hard to prove. Even if you could prove it, there'd be a suspended sentence, which the other side decided that was going to be a victory of sorts. And pretty quickly, it was very rare. And I guess the best example of how ineffective it is, in 40 plus years, there was only one party on the other side who ever actually went to jail.
No, you got to tell that story.
And she was 70 years old. And in the case before, every once in a while, they had a lot of property and she wouldn't sign to close an escrow. And the only thing we could do, because it was going to fall apart, we'd file a contempt. She'd show up in the morning and she'd say, "Oh, I'm happy to sign this." She'd sign it. We'd take it off calendar. Case is all over. She has gone to the bank. She has taken a chunk of money in a cashier's check that he actually needed. And, and she's got it hidden and it's a cashier's check. So we bring a contempt and it's going to be the usual thing. And she comes down there and this is in front of Judge Julius Title, who some may know, which will give context. And he comes out and he says, I keep the names out of all this. He says, "Ma'am, you're in contempt and you're going to have to return that check because there's a judgment. And if you don't, you're going to go to jail. And I don't mean for 5 days. It's a contempt until you turn that check over. You hold that check for 6 months. You'll stay 6 months." And he said, "But it's Tuesday. I'm going to continue this matter till Friday. And you think about this and you come back Friday." And in an open courtroom, she stands up and she says, "My husband's a crook. Your Honor, my answer is no today. It'll be no on Friday. And I'm sorry I voted for you in the last election." The courtroom was just stunningly quiet. And he said, "Bailiff, escort her to jail." And on Friday, she wasn't going to release the check still. When they brought her in her little prison dress, she said, "I get 3 meals a day. I don't pay rent. I like it." And the only thing we could figure out is her attorney had a very funny comment. He said, "First time one of my clients got life." And because he only did family law. But she eventually turned over the check when the judge said, "While you're in jail, your husband is going to go to all your apartments, collect all the rent, and keep it." Now, what that meant was with a writ of execution. But that's all she needed to hear. Check will be there at 1:30. So, and that's it. Of the really bad people I brought contempts to, none of them got to jail. One of them was sentenced to jail, told to report, and claimed that when they got there, they were just sent away.
And it's all true. Before I went on the bench, in one of my past lives, I was a partner in a firm called Center for Enforcement of Family Support. And all we did was chase deadbeat dads, and also on occasion, but I promise with equal enthusiasm, deadbeat moms. And we also had exactly the same view as Jaffe and Clemens, which was contempt was absolutely our last resort. We had to be really motivated because it's just not an effective way to get compliance most of the time. And Contempt is also hard to do. Family law lawyers as a group have a hard time meeting all of the technical requirements because it's basically a quasi-criminal procedure. And if you don't have criminal law experience, it's really easy to fail at what you would righteously think ought to work. I did have one case, however, where the husband had committed the worst offense ever in a family law case. Everybody goes, what's the worst offense ever? And of course, the answer is failure to pay court-ordered attorney fees.
I agree.
The wife's lawyer brings 4 counts of contempt against him. He's convicted. I sentence him to 5 days in jail on each count, suspended. He's put on summary probation. This is the typical sentence you get in a contempt. But one condition was that he do 100 hours of community service on the freeway because, that does sort of get people's attention. Months later, I said to the clerk, I wonder what happened on that case. She says, I'll call and find out. She comes back. She says, he never even reported. Now I'm not happy. And I set an OSC to revoke his probation. Everybody shows up. The lawyers for the parties say, well, we're happy to tell you we've worked it out. And I go, that's nice. That's not why we're here today. I was going to give them all 20 days, but I decided I would just give them 5. And I said, 5 days, come back next Monday, and you're going to jail for 5 days. Well, next Monday turned out to be the day after the Northridge earthquake, and the courthouse was closed. But on Tuesday, he showed up. He says, I made it to the courthouse yesterday afternoon, and it was closed. I says, I'll give you credit for the yesterday, but you still have 4 days to go. And by God, he went and served all 4 days. Now, why do I talk about that? Because the answer is that was long, long, long ago. And today, even if the bailiff takes him away, they're going to cut him loose. They will not, in fact, incarcerate him because there's no room in the Gray Bar Hotel. So I can't say that the contempt should never be used, but it's really a limited remedy.
Sounds like it's a little bit lose-lose. Zooming out a little bit, what are the overall keys to practice of family law?
I'll let Bruce
Either one of you could take it. That's for either one of you.
Yeah, I guess I'll start. Everybody has to learn the basic rules, the basic process, the basic procedures. But what really makes it remarkable is the creativity, the situations that are abnormal and aren't going to lead to a good result. But if you've got enough creativity, maybe you can do something extraordinary. In the handouts, there are only 2. One, by the way, is just a 1-page document that was put together actually at my request by is no longer living, a psychiatrist named William Glasser, who had bestseller list on the Times and all that. And it basically is everything he knows in all his books in 1 page. And it's very appropriate in family law. The only person you can change is yourself. And the other person's going to do what they're going to do. You might have things that may want them to do different, but it's up to them. And the other handout is from a case called Kilroy v. Kilroy, and it's the creativity part that all of the lawyers out there, the judicial officers out there, we all have the same issue. What do we do when it's non-standard? In Kilroy, she had a prenuptial agreement. She came into my office, and it was extreme wealth. And the prenuptial agreement said if she files for divorce, she gets, and I'll pull a number out of the air to be non-specific, $5 million. But if he files for divorce, she gets $10 million. I said, well, you don't want to file for divorce then, do you? And she said, that's what I said to the prior 2 lawyers. And they said, I have no choice. And I said, why is that? And she said, well, all my credit cards are unpaid. My bank account is empty. I never knew these things were happening. We have 2 floors at the top of one of the high-rise condos on Wilshire, and I can't get into it. I'm locked out, and I'm sleeping on the couch at the first floor in the reception area, and I need help now. I can get a little bit of help from friends, but I need help now, and I don't want to file for divorce. And I said, let me see what I can do. And there was nothing in treatises or anywhere else, but with a great lawyer who I worked with, David Luboff, and always Dan Jaffe having incredible ideas, we found that there is, and this is back in the 90s, you wouldn't find it in treatises then. It's not just that you have a legal obligation to support your spouse in an intact marriage. That's fine. So sue them. We did that. And the other side, of course, is good. You can have a trial in 2 years. And if we really have to support you in 2 years, we'll start supporting you. And by the way, you can't get temporary support because it's not in the statute. It doesn't say you can't, it's just not in the statute. Well, that's like saying, if you want food and air, sue me and you can have it in 2 years. It doesn't work. And we were able to find a method. They couldn't even figure out if it was a family law judge or a civil judge, but ultimately we got temporary support, went to the Court of Appeal, sustained, and it was, I call it the creativity, because I'd never seen the problem before. It's just as lawyers and judges, you learn not to accept failure without having tried everything. And I'll leave with one more. It was a settlement that got arranged, and the one side had a lot of extraordinary real estate developments. They also had a lot of tax benefits that would save a lot of taxes, but only against the income from that same type of work. And that wasn't what the wife was going to get. So when they got divorced, it turns out those tax benefits aren't divisible. So she would get half and never use them, and he would get half and use them, and millions would be lost. And I thought about it, and we all do bifurcations. You get divorced first, the status, and then you do the property divorce later. I said, how about a reverse bifurcation? How about they get divorced in every way, financial, except they stay married for 5 more years? They file joint tax returns for 5 more years. They burn off all those tax credits over the next 5 years, and they've got millions of extra money to make the settlement work more easily. We hired my law professor who was a tax professor from law school, and he said, oh, I've never seen anything like this, but I think you're onto it. And we did it, and it worked. This was a long time ago, 20 years ago. That's the creativity that mediators, attorneys, we all bring in when we can't find a good answer, as opposed to just saying, well, the law says no. Sometimes it says no and there's no solution, but that's what we all have. That's what we all bring. Everybody out there does it in different ways. I know that.
So Keith, if Bruce says creativity is the key to practice, what's the key to practice to you?
I think it's look, you bring your whole life experience to the family law party. I remember talking to Judge Eli Chernow when he had been in family law for 1 year, and he had had a long, distinguished career as a civil judge, and it was distinguished before he went on the bench. And I said to him, how do you like family law? And he says, family law, he says, calls by far on my total life experience, far, far more than anything else I've ever done. And he's right. And that's part of the reason family law is interesting. It's not cookie cutter stuff. It's every one of these cases involves real people and specific details. It all matters.
So we're going to get into more of the personal history in a sec, but I feel like it's, today we focused a lot, almost like teaching. And I know you both have taught a lot of classes for the state bar. When did you start doing that? What was it like at the start when you started that? Maybe Bruce, why don't you take that one?
I'm smiling because thanks to Dan Jaffe, who was much more experienced and known at the time, he made it possible that we started doing programs together in the late 70s, early 80s, and family law was new because up until 1970 it was fault divorce, and it all of a sudden became an accounting, tax-driven, etc. thing. And the second program, we're going around the state to about 200 people at a time, and taxes. It was a tax program for family attorneys, and boy, they really weren't attracted to that in general. I kind of joked that most of us in family law, wasn't for me, but we were family law attorneys because we didn't want to do taxes and things like that. And but I wasn't really known as a lecturer, and I took a chance. And what I did is, and I'll reenact it, I had the Internal Revenue Code with me, and I held it up and I said, how many of you have the Internal Revenue Code in your office? And there's about 3 hands that go up. And I said, well, let me tell you, it's not like you think. There's only a few sections that really matter. And don't worry about it. It's not dangerous. It's not going to burn you. You're not going to be harmed by this. It'll be just fine. And I put it down, and I knew I'm either going to be ruined professionally from this, or it'll be okay. And for 5 seconds, there's dead silence, and my life flashes in front of me. I'm ruined. And after 5 seconds, a huge round of applause. And from that point forward, they're listening to everything we're saying about tax intently, except they're really waiting to see, is the book going to burn again? And that's how I got started in lecturing, and I loved it. And poor Dan and poor Keith, because I've lectured with both of them, every time I do something from that point forward, somehow we need a flaming book, and they're really tired of it. But I enjoy it, and I hope you guys did out there.
So let's go all the way back. I want to go all the way back towards the beginning. What was the Clemens house like when you guys were kids? Keith, why don't you start off? Was Bruce always lighting things on fire? Is this where it started?
Well, the answer is no, he wasn't. But remember, we were almost 4 years apart, and that's a fairly substantial difference when you're growing up, particularly when we grew up back in the dark ages. And no, he was just an ordinary kid. I was just sort of an ordinary kid.
So what do you remember most about Bruce from that time? Even my sister's 4 years younger. I get it. It really is separate worlds. But what do you remember most about Bruce at that time?
As I said, we were brothers. We had lots of shared experiences, but we had different lives. I had my friends who were my age. He had his friends who were 4 years younger. It was different, and we actually became much closer after I went off to college, and then somehow we really got very tight.
Bruce, do you remember Keith as a kid? What do you remember of Keith as the brother as a kid?
It's just as he said. When you're 8 and your friends are 8, and you have a brother who's 12 and their friends are 12, it's a lifetime difference, and you don't even get with TikTok and internet and everything else, the shared experience. People today know a lot more. This is in the late 40s, early 50s, late 50s. Television was just being invented as far as actually in houses. And there were 3 channels, except they'd go off the air. They weren't on that long. And so we grew up in San Francisco. We grew up in a neighborhood, small house. Each house is next to the house. You know your neighbors, you know the people at your school, but you don't know things now. And so 4 years apart, If I'm finally 14 years old, he's off to college at Berkeley and then Harvard. I'm trying to get through Lincoln High School at that point, which was famous a year after I graduated, and you had the Haight-Ashbury, the Summer of Love, etc. Turns out the teachers, after I left Lincoln, thought, well, the students, if they want to come, they should come. If they don't, they don't. If they want to take tests, why should we put any pressure on them? And my high school in San Francisco lost its accreditation for a year. I thought, what will I do? So that's a long answer to
Probably go to Golden Gate Park.
We had separate lives growing up, except when the big families got together. On my mother's side and on my father's side, we would all get together, and then we're all together. But it's exactly as Keith said, later in life.
So Keith, when you were growing up, did you know what you wanted to be? Were you always destined to be a lawyer from the start?
No, not really. I mean, although I will tell you, as a kid, I thought that being a judge would be really cool. I only knew that from seeing a picture of a judge on the front page of the Chronicle. But we didn't have any lawyers in our family, and that was really far removed. Did I think about that possibility? Yes. But I just didn't initially plan to go. I preserved my options. I did take a year of accounting as an undergraduate because in those days, Bolt required you take a year of accounting, and if you didn't, they made you go to summer school before you started law school. But I hated every minute of it, but frankly, it was a very valuable year. As that actually learning accounting, at least some accounting, is useful, and I became very comfortable with it. But no, I decided I wanted to be a professor. I was going to go become an economist, and I did more graduate work in economics than I want to think about.
What was your focus? Why economics? Why international economics specifically? I think. What drew you there, and why? More importantly, why was it not a fit for you?
Good questions. I had taken some classes in studying the Soviet economy, and one about the Yugoslav economy, which was sort of a hybrid. And I just thought, well, that might be interesting. And then this is in the mid '60s, and China exists. And I thought, it'd be interesting to study about the Chinese economy and how it's similar to or different from the Soviet economy. I thought that would be interesting. And I did a couple of graduate years at Berkeley, and actually started taking Chinese, and it turns out I have no more talent for Chinese than I do for any other foreign language. And professors there said, look, if you really are interested in studying China, there are two places to go, Michigan and Harvard. And that led me to say, okay, I'll go back and I'll see if I can go there. And as it turns out, Bruce and I decided we would take a trip across the country in his '66 VW Beetle in the middle of winter to drive to Ann Arbor and then Cambridge. And that was a great experience. Understand, we've heard about snow. It's not like we've actually experienced it. We ended up in the middle of the horrendous blizzard in upstate New York. Took us 3 days to get through there.
But the little bug made it?
It did.
It was a Volkswagen. Those were great. We all know that the VW Bugs Beetles were indestructible. And I ended up getting offers to go to both places, and Michigan offered me a $2 an hour research job, and Harvard said, would you like a National Defense Foreign Language Fellowship? I didn't think that was a hard decision.
And Bruce, go ahead, finish.
I'm sorry, go ahead, Lauren.
No, finish your thought, go ahead.
Well, but somehow none of this really gelled for me. In fact, I ended up taking a leave of absence, going to work for a consulting company as an economist, and this was Apt Associates in Cambridge. And I will tell you that one of my coworkers there was a young woman named Aviva Konigsberg, whom all of you know as Aviva Bob. So our lives met there. She then went, this was before either one of us went to law school. And then, of course, our lives reconnected a couple of times in the subsequent decades. But eventually I woke up one day and I says, I don't understand what's going on. And not only do I not understand it, I'm not sure anybody around me does. And if they don't understand it here, they don't understand it anywhere. Time to do something else with my life. And I decided to go to law school. And I was 27 when I started law school.
Wow, that's quite a change. Bruce, what about you? I know you ended up at NASA before your own law school experience. How did you pick college? How did you end up at NASA? And then how did you transition to family law practice?
Well, I think all of us out here today who became lawyers had a different reason. And I think it's more common. It wasn't my parents were lawyers. I wanted to become a lawyer from the time I was, a lot of circular routes getting there. And I had a circular route. For me, mathematics came very easily to me, and it was very interesting and it was fun. And my undergraduate degree was in mathematics, and then I had 2 majors and statistics. And then I went to graduate school in computer science at Stanford, when there were only 5 universities then in the country that taught computer science. That's how old it all was. And I worked on the Apollo project. That's getting the first man on the moon. And while it sounds wonderful, and I did it very well, and it didn't fill me with what I needed. I love working with people. I love being around people. I love the interaction too, and in addition. And it's a pretty quiet, back then, being a computer scientist was, or systems analyst is pretty quiet, slow moving pace. And when I got the opportunity, I said, I'm going to go to law school. And I wasn't sure why, except I had always done things that I imagined lawyers would like doing. And it was by accident. And I went to be a litigator, civil litigation, and I went to work at Loeb and Loeb. And by accident, although almost all the large law firms in the state did not do family law at all intentionally, because it's a good way to lose a long-term client, represent them in their divorce. Jerry Goldberg was partner there, and he was, anytime you ever had to say, name the 3 best or 2 best in the state of California, he was always on the list. And I say it that way because if I said he was the best, then it would offend some people who think they were the best, and maybe they were. And the light bulb went on, because when I'm doing civil litigation, we're working on the equity funding monster case with fake life insurance policies and all that. And it's like, oh, this is going to go on for years and years. Family law, I'm up at 3 a.m. worrying. So are my clients. We're using psychology and financial things and personality and all those things. And my wife of now 48 years, Brandy Ruth, is a psychologist. She was an inner city school teacher and then went back and got a doctorate. So she always tells me all the good advice I gave when I was younger was wrong. So I learned I got home tutored. And that's the long-winded answer of how do you end up from a math major into family law? It's the natural path.
So we're bumping up against our time, but I have a couple more questions just about the business side of law and creating law firms. You guys did decide to work together at one point. How did that start? And then why did that end, Keith?
Well, I started at Greenberg Glusker, by the way, where my mentor was Dennis Wasser, although I only worked on civil cases. Dennis did both civil and family law at Greenberg. And Bruce was at Loeb, and when Bruce was toying with the idea of leaving, and I toyed with the idea of leaving, and we said, well, we can do this together. And we decided we would both leave our firms and set up a shop. And Bruce said, I'm going to try doing family law. And I says, I will specialize in everything else. And after a couple of years, I said, specializing in what comes through the door is really not the way to go. And I left and went to another firm.
And then Bruce, when you started Jaffe and Clemens, how did you and Dan, an amazing friend of our program and personal friend to all of us, how did you guys connect and start working together? And what made that firm, still makes their firm, but together, the two of you as partners, what made that such an indelible partnership?
I'm not going to exaggerate. In the 45 or so years we were together, we had not a single disagreement. I know that sounds amazing. It is not an exaggeration. I've helped just to help people start their own firms. And the view is, I need a partner. And then the two of us or the three of us, and I always tell them 1 + 1 has to equal 3 in order for that to make good sense. Because if you're no better separate than together, then one of you pretty soon will think you are the better of the two and wonder why you're only getting half. And the other one of you, who is not quite equal, thinks they're at least equal or more, and how could it even be questioned? And that goes in all sorts of ways. I was in what was then called a Fijian suite that had about 35 lawyers independently renting offices, and there were shared libraries and things. There happened to be 5 family law attorneys, including Dan Jaffe, on that same floor. And over a couple of years, I got to know them, and we worked together. And we were so different at some ways that we practice, and so absolutely in sync in the ways that mattered, that by putting the two of us together, we could start hiring a lawyer, because it was more, and then more after that. It was a deferential. If it mattered to Dan, why would I argue? If it mattered to me, why would he argue? And I did much more of the business end, the managing partner thing. And Dan, as you guys know from talking to him, and many of you know out there, it's kind of a miracle in the way he does things. And he helped so many of the lawyers. I remember when I was a young lawyer, I went to him and said, Dan, my client wants me to write this letter that says this and this and this and this, these horrible things. And I said, I don't know that. I can't do it. And I don't know what to do. And he says, oh, just start your letter. It says, my client has instructed me on his behalf to say the following, send the letter. Second he said that, it was obvious. Well, when you can help people like that, and Dan and I tried to help others, and others helped us, that's what made that firm work. We did very, very good law, and we were very lucky to get great opportunities, and we didn't screw them up. We had the hardest, largest cases around. We were not on radio, television, anything. We were about as stealthy as you could be. And that's just because that's how we both learned to practice. And that's what made the firm. And Dan's still practicing. And he's older than either of us.
Well, really quickly, with our last 60 seconds here, because we're having such a great conversation, we find ourselves running out of time. Keith, what led you to go into mediation instead of riding off into the sunset when you retired from the bench?
Well, I left the bench. I was way too young to retire. And I deliberately left to go private. I had kids who were getting older, and college was imminent, and doing this by the hour worked out a little better than doing judging on the bench, particularly for a commissioner. Payday is not among the good days at the courthouse. And that's how I did it. And I've been doing this now a lot more than 2 decades, and I like it, and it works for me. It fits me. Bruce loves lawyering. I did not particularly enjoy lawyering, but I had to do it. I like being the guy in the middle. I think was built to be the guy in the middle. And that's who I am.
Bruce, same question for you with our last negative 30 seconds. What led you to go to mediation instead of closing up shop completely?
Well, first of all, I love the practice. The building we were in got sold, and we were going to have to build out a whole new suite, change the addresses, do all that stuff. I was 72 years old, and I said, I don't think I want to sign a 10-year lease, et cetera, but I love the work, and I've tried to do a lot of teaching and volunteers and pro tem, things like that. And I had done some mediation. I said, I think I want to do mediation to give back and to keep my brain from atrophying any faster than it might choose to atrophy on its own. And I've just loved doing it. And it's wonderful.
Okay, last question for me, guys, really quickly. Bruce, what's the final, what final advice would you give your younger self or new attorneys just starting out in family law?
Boy. I'm having trouble answering that question. I think I'm going to do a slight sideways. One of the things that Warren Buffett said about what made his businesses do right, be well, is he had a saying. He said, delight your client and everything else will take care of it. He says, don't satisfy your client. Actually, he would say customer, delight your customer. And to the lawyers, if you love what you're doing or you like what you're doing, and you figure out what does it take to delight the people you work with, the clients who hire you, the judges you're in front of, and you figure out how to delight them, you'll delight yourself and you'll have a career beyond imagination. Everything else is details.
Keith, take us home. What final advice would you have to somebody just starting out in family law?
I'm just going to say Bruce has the right attitude. The answer is that you are a lawyer. You need to learn your technical skills. You need to think about being ethical the whole time. And if you do that, this works. And be prepared to worry about your client at midnight, because that's just sometimes what it takes. You find your passion and you do it. Now, if I were giving advice to myself back when I was starting, I would have said, who cares about any of this? Bruce mentioned Warren Buffett. My advice would have been, go buy some stock in Berkshire Hathaway.
Oh man, Bruce, Keith, thank you so much. And thank you everyone for sticking around as we went over a couple of minutes. It's a shame to have to wrap this up. Please do mark your calendars to join us for our next episodes on January 10th with Judge Shelley Kaufman. Then after that, it'll be the first Wednesday of every month featuring Michael Trope, Camilla Klein, Adam Lipsick, Evan Itzkowitz, and more. We want to thank Genna, Rin, Jose, and Belinda from the bar, the Family Law Executive Committee, currently led by Ava Jahan-Bash and Ashley Kwan, and of course, our section sponsor. Most importantly, thank you again, Bruce and Keith, for being here and sharing so much. We'll see everybody again in 2024.
Thanks for the opportunity.